This is actually about the case that went before the Supreme Court on 1512 yesterday, and we have...
Oh, the 1512. Okay,
yes.
Okay. Perfect. Yes. 1512.
Okay, and we have an attorney here who prepared the amicus brief for that case, and she is willing to tell you...
Oh.
She is willing to speak with you guys and kind of give you an insider's view of what happened. Are you ready?
Yeah, so not Jake Lang's lawyer.
No.
Sorry to disappoint.
No. Trust me, you haven't.
Sorry to disappoint.
No.
Or do you want to plug in?
This is for the Fisher case.
No, I know. I'm joking.
Yeah, I know.
Nor am I Aaron Brockovich.
So let me know when you guys are ready.
We're good.
All right.
I'm ready.
Hey y'all, how are you tonight? So my name is
What's going on?
Paloma Capanna, and I'm an attorney and policy analyst, and I have been with you since the afternoon of J6 as events were unfolding at the Capitol.
So
and I first saw every single TV station across America zooming in on patches that said Oath Keepers, as if there had been some kind of a memo that I didn't get. On yesterday, oral arguments were had at the United States Supreme Court. All 9 of the justices were physically present in the courtroom. Justice Thomas was absent the day before, but he was present for you yesterday. Oral arguments at the U.S. Supreme Court are allotted as 1 hour for each side. Mr. Green presented the oral arguments for defendant Mr. Fisher, who is leading the charge on the appeal against 18 U.S.C. section 1512 C2, which we all know was devised by U.S. DOJ attorney Michael Sherwin, then heading the Washington office of the DOJ, as his shock and awe charge carrying that 20-year federal felony threat. The first 75% of the full 2 hours of oral argument, I would suggest to you, was fairly academic, almost to the point that I think everyone in the room felt like they were in law school. You know, if you've looked at 1512C2, it's 1 line worth of text, not even its own sentence. And so you can imagine that for an hour and a half, all that's happening are people discussing the definition of the word otherwise. And then there was a moment that the whole thing changed. One of the questions was Chief Justice Roberts asking the United States Solicitor General whether she had charged any persons with 1512C2 who have protested at a courthouse, specifically the United States Supreme Court, where as recently as last week, 5 persons were physically arrested in the courtroom for disrupting proceedings and taken out of the courtroom. Much, I think, to the shock of everyone in the room, the Solicitor General did not take ownership of a failure to charge or protect protesters at the United States Supreme Court with the same level of intensity as the prosecution of defendants concerning the events of January 6th. And the other judges then became a rugby match. So if you get the opportunity to hear the oral arguments, fast forward through the first 75% of it, right? Get to the good stuff. Get to the part where people in the audience started leaning in, and I myself also started counting votes. Will it be 7-2? Will it be 9-0? Will Justice Kagan be a holdout with a dissent because she's got just a different tack that she's taking on interpretation? I think that if you can get those oral arguments and listen to that last section, you will be surprised to hear judges, including Justice Ketanji Brown Jackson, asking some of the most pointed questions concerning free speech and the balancing and where that line is and whether 1512c2 has anything to do with anything of the above. Your hero of the day, however, do you want to guess who I'm going to say was your hero? Who was your champion of the day? Any guesses?
Who was it? It was, I can't remember his name. Wisconsin. No, Gorsuch.
Oh, he gave the death stare to the Solicitor General, so yes, but Justice Alito. So the first thing to tell you about Justice...
Scripps didn't say anything about that.
Oh, yes. Oh, yes. So, listen, let me tell you this about Justice Alito, who even I myself did not realize he has very broad shoulders. Literally, physically, large, broad shoulders. He was so prepared yesterday. He had worked through the hypotheticals and just started grilling the Solicitor General. So picture, if you will, she's standing at the podium, he's asking her questions, she starts reaching for the glass of water, and reaching for the glass of water, and reaching and she reached for the glass of water till that glass of water was empty, and she kept reaching for the glass of water. She kept talking faster and faster and faster and faster, and Judge Gorsuch starts closing his eyes. And Justice Thomas rocks back in his chair. So far, I think he's going to fall. Justice Roberts is trying to sit politely. Justice Alito, who has been rocking back and forth in his chair, is now leaning further and further and further forward, completely unsatisfied with the lack of response to his questions. So, I am not sure that at the start of the oral arguments I would tell you that 1512c2 was going to be thrown in the Potomac River. However, at the end of the 2 hours, it was surprising how the mood had shifted. I cannot, as an attorney in any good conscience, tell you how I think this will come out. That's just not appropriate. There's days for me where oral arguments, I leave and I'm like, yes, I nailed it. And then you get like, the ruling is completely against you. So, I cannot say that. But I would say, without equivocation, I'm 30 years in courtrooms and with quite a bit of appellate work and within the federal system, and currently have a petition for cert pending before SCOTUS. Every single one of those 9 judges was ready yesterday for oral argument. And at the end of the day, the only thing that as an attorney you can ever pray for is that they have read the damn papers. And I will tell you, they read the papers, they dissected the papers. At one point, Justice Alito held up a brief from another case that was beat up. I mean, you should see how hard he is on his papers. The thing is practically falling apart. So, if I can offer you any word of encouragement for however slighted you may not only feel, but objectively speaking, have been treated in some of the interim decisions and final decisions and sentencings that have been handed down. The nation's high court did not disappoint yesterday in their preparedness for the issue and for the severity of the issue faced by those of you either convicted of or facing that 1512c2 charge and the threat of serious sentencing.
So how about that, gentlemen?
I think it's a 9.0. Right. I think they're going to rule it all the way across the board. I think so too. And the only thing that I wish would have happened at the same time would have been and I don't know if this works with the law, is sort of a broad, hey, how can you charge January 6ers with one special time and every other protest out there, and bring in Chief Stunt, who said today, hey, listen, if you're going to call January 6th an insurrection, then you have to call the 3-day riot at the White House an insurrection as well. It should have been a broad, call an apple an orange, basically. How are you going to go at the fullest extent of the law on January 6th, but never went there before or after January 6th?
Pick and choose what you decide to.
Yeah, I mean, you can't, that's not how the law works. And I wish, with all the money that I spent on lawyers, I wish one of them would just say, hey, listen, let's just get you through trial. If you're guilty, fine, but let's spend this money going all the way up to the Supreme Court, which one of my lawyers said that he was going to do, but then we realized that he was full of garbage.
So there's actually quite a bit that I could unwrap from that, but perhaps the best thing I can do is just give you a little bit of procedure of what happened. So Fisher versus U.S. is, of course, the first of what will follow many cases involving January 6th. Even for Mr. Fisher to get there, it was a joint D.C. Circuit Court opinion that was appealed, affecting Mr. Fisher, Mr. Miller, and Mr. Lang.
Yeah.
When that joint D.C. Circuit Court opinion issued, each defendant's counsel submitted a separate petition for writ of certiorari asking the court to choose this decision on appeal. Understand the odds are about 8,000 cases, 80 selected, about half criminal. So the 3 petitions went in, and Mr. Fisher's was selected then from among the 3. So it is, in ways I cannot imagine, gentlemen, so slow, so painfully slow. Even for me as an attorney, waiting, where is a case so that I can start submitting amicus briefs with some of the research that I've been working on. But I hope I can get across to you this. So an amicus brief is 8,000 words.
Still too hard, but like feel
The petition is 9,000 words. It takes so many hours to get that put together because you have to have a horse that wins the race against about 8,000 other horses. And it's there, and it's just the beginning. There will be so many cases to make it. The judges were so interested in your case. They understand the implication for more than 350 defendants. Hang in there. Hang in there.
So there you are, gentlemen.
The 1512 is the first domino of many to fall.
Amen. Yes.
They get the 1512, everything else will fall into place.
Amen. Godspeed, brothers. You stay strong in there, all right?
Godspeed to y'all.
God bless. Have a good